I am still kind of just learning about the dividend thing, but I found out about it because his ex-girlfriend told me about it, and turned out since the day Garrett was born, he had been getting like $10,000 every 3 to 4 months, and half of that was my son's money.
It's just that, Your Honor, if they're a married couple, then it's our agency's policy to not to request the cash medical
Okay.
reimbursement.
All right. Starting with this intense custody battle between Mr. Caldwell and Miss Proctor, you're the father trying to re-enter his son's life after years away, only to face allegation of abuse, threats, and drug use from the mother in court. Let's see how the judge handles this.
Mr. Caldwell, can you state your full name for the record, please?
Yes, Paul Caldwell.
Thank you. And Ms. Proctor, can you please state your full name for the record, please?
Ariel Proctor.
Thank you. And Mr. Doe Constantine, can you state your full name for the record, please?
Karen Rideau Constantine.
Thank you. And can all three of you please raise your right hands to be sworn in? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
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 Thank you. You can lower your hands. And counsel for the Attorney General's office, please state your name.
Johnny Petita.
And Ms. Petita, are there any agreements today?
Yes, Judge, there are. However, before we begin, Judge, I'd ask the court to take judicial notice of our pleadings on file that we filed on August 12th, 2024, and the attachment thereto, which is an acknowledgement of paternity.
I take judicial notice of the pleading. Can we now get to the agreements, please?
Yes, Judge. Judge, there's only one agreement between the parties, and that is to child support, for current child support. The agreement is for there to be child support to be set to $0 as the child is receiving dividends through the Arctic Slope Regional Corporation.
I'm sorry, no, they're receiving dividends through a corporation? Is that what you said?
Yes, Judge.
Okay, I'm going to need testimony on that. I'm not sure that warrants a deviation, but maybe it does.
Okay, Judge. That's fine.
And does everyone agree that this is your child, Mr. Caldwell and Ms. Proctor? You both agree that the AOP was signed and Garrett is both of your child?
Yes, ma'am.
Okay, you may continue, Ms. Petita.
Okay, Judge. Since of course my testimony on the agreed child support, Judge, I'll call the parties first. I'll call Ms. Proctor.
Yes, ma'am.
Ms. Proctor, you previously identified yourself. You are the mother to the child in this case. Is that correct?
Yes, ma'am.
And Mr. Caldwell is the father of your child?
Yes, ma'am.
Let's see. The child currently resides with you?
Yes, ma'am.
And what kind of conservatorship are you asking for the court?
Considering that he has been absent since the child was 6 months old, I would like the safe visitation program for the first 6 months.
Asking for about conservatorship, right? Are you asking for joint managing conservatorship?
Oh, okay. It's sole managing conservatorship.
And what is the reason for wanting sole managing conservatorship?
Because I've raised him by myself since he was 6 months old, and he is almost 7 years old now. I have not asked for any kind of help since he's been born. I haven't really I haven't involved Paul that much because he has a drug problem and I just don't agree with the drugs he does. He's also threatened to kill me and my child, and I have proof of that as well. I don't feel like it's safe fully yet because there's a lot of growing to do.
When did he threaten to kill you and your child?
It was in 2022, and that's what initially, I have a screenshot of it, but that's what initially made me kind of cut complete contact off, because there was a lot of threats during the relationship and a lot of physical abuse during the relationship as well.
Okay. So do you have concerns with him having your contact information?
He has, his girlfriend has me on Facebook. That's as far as it's gotten. I would rather him not have my contact information, but he can message me through Facebook, and he is not blocked or anything.
As far as your phone number and address, are you asking the court to grant you a non-disclosure of your information today? I
would like that, yes.
Okay. Now you said since 2022 you cut off communication with him. Since 2022, has he communicated with the child or seen the child?
He video called him about a month and a half ago because my son was having a fit to talk talk to him, and I'm not going to keep my son from talking to him because he is getting older, and I would like for him to have a relationship with him. But I want I just don't want the drugs and the threats. I'm still very uncomfortable with it,
Okay.
especially because he's never been, they
Since
don't have
20
a relationship.
since 2022, has he threatened you again?
Yes, he's threatened me multiple times.
Okay, and how?
Do you remember?
Yeah, he told me he was gonna turn the insides.
Ma'am,
inside
Judge, objection.
ma'am. Sustained. You cannot have a conversation with a third person to affect your
Oh, okay.
testimony. If you don't remember, you can say you don't remember and you can call witnesses, but this is not like getting
Okay.
testimony through
I
other
don't-
people. That's not appropriate for court. You were here on the witness stand. If you were in court, you couldn't have a side conversation with someone who wouldn't even be sitting at your table. So just
Okay.
think of it as court, and just, if you don't remember, you don't remember. But please don't get information from other people. It's not appropriate.
Okay. I didn't know. I've never done this before.
That's okay. I'm just, now you both know.
Yeah, he walked off, but it's just been a lot. I just cut complete communication off at one point and just stopped responding because I have screenshots that I could send over that it just kind of shows it all, where he's threatened to turn my insides out and lay me on the side of a road. He's threatened to take Garrett from me and kill me and then tell Garrett all about it. Like, I have all this from his Facebook that says Paul Caldwell, and just lists
Okay.
of constant mental abuse, threats. I just stopped responding.
Okay, Ms. Proctor. And you also mentioned that he uses drugs. Do you have personal knowledge of that?
Yes, actually, I let him come to Garrett's birthday party about 3 years ago, and he left his phone there, and I took a picture, which I don't know if it's illegal or not, but I took a picture of the notifications on his thing because I wanted proof that he sells drugs, and it literally says that someone was trying to sell him an ounce of cocaine for $700 on his text messages that would pop up on the screen. I couldn't click on it or open it. I just took a picture of that, and I have the picture of that as well. But
Okay. Is that
there
when is the last time that he saw your son in person?
on his birthday about 3 years ago, and it was for about 30, 45 minutes until he was asked to leave because he body slammed my dog into the ground.
Okay, ma'am, if you could just listen to the questions and not give extra answers, it's very hard to follow when everything gets followed up with more information. And I know you want to share it all and you're happy to, you're excited that you're getting to tell your story and I want to hear it, but I lose a lot of it when people just explode information at me. So listen to the questions Ms. Petita will ask. At the end, you will get a chance to just talk. But right now, Ms. Petita is trained. She knows kind of what I need to hear. And if you just answer what she's asking, it'll get through to me a lot better.
Yes, ma'am.
I appreciate Ms. Petita.
Okay, so you said he last saw him about 3 years ago at his birthday. Before that, did he have any kind of regular visitation with him?
No, he has never had any kind of regular visitation.
Okay. So what kind of visitation are you asking the court to order today?
Preferably, I would like if he was in the safe visitation program for about 6 months, considering they don't know each other really. And then after that 6 months, maybe supervised by a family member or somebody close to both of us, that can mediate and be supervised visitations for maybe another 3 months, and then ease his way into having him every other weekend because he is still young and I don't want him to be confused.
Okay. So are you worried about your son being confused or about his safety?
Really, all of it, the drugs. I don't want him to be confused being with, someone he doesn't really know that well. I've never really let my son go anywhere like that. I don't want the drugs around him. I just, the way he used to act towards me and still is concerning because some people take that out on the children. I just don't think he's mentally stable enough to have a child overnight or by himself.
Okay, so you're asking the court to grant you a step-up visitation plan, is that correct?
Yes, ma'am. It's where they go to the little centers and I can drop him off and he can see him there.
Now, when did you and Mr. Proctor or Mr. Caldwell separate?
When Garrett was 6 months old.
About what month and year was that?
It was maybe December of 2018. That's when we split.
Now, since then, have you all lived together again?
No.
Now,
Did he do all the drugs and stuff when you were all together, or has that all been after separation?
It was going on while we were together, and that's what caused the separation because I don't do stuff like that and I don't agree with it. And he chose the drugs over his family, so.
did he have supervised visitation with the baby after y'all separated? Did you do any kind of visitation?
My mom would let him see him here and there before he was about 2.5 years old. That stopped because that's whenever I got the threat that he was going to murder me and tell Garrett about it. And so I told my mom to stop letting him see Garrett because of that. And my mom had agreed with me. So when he would see Garrett, it was very vaguely, and it was with my mom. My mom would just ask like, "Hey, is this okay?" And I'd be like, "Yes, that's fine." Because there was nothing too serious going on at that time, but Garrett was barely 2.5 years old. And then he threatened to kill me, so we cut it off.
Now, did you hear me say to the court earlier that there was an agreement between you two for zero child support in exchange for your child receiving the dividends?
Yes, ma'am.
Correct. Okay. Can you share what that means?
I am still kind of just learning about the dividend thing. I learned about it in November of 2023 that my son was getting paid from Alaska from some company that Paul and his family, I guess, invested in. I'm still trying to understand the whole thing. I don't fully understand it yet, but I found out about it because his ex-girlfriend told me about it, and turned out since the day Garrett was born, he had been getting like $10,000 every 3 to 4 months, and half of that was my son's money. And I wasn't even aware of this until about a year and a half, 2 years ago. And when I found out about it, I contacted the Arctic Slope Regional Corporation, and I informed them that I've had the child since he was born, and that these dividends of my child's are going to the wrong parent. And it took me about a year and a half, which would be about 3 months ago, to finally get Paul to sign over all the dividends to me. And I still don't understand fully what it's from, but every 3 or 4 months, my son gets between like $2,000 to $4,000, and Paul was living off that before I got it. So
Okay. So at this point,
Yeah.
you are receiving those dividends for your child.
yes, I am now.
Okay, and your agreement for there to be there to be no child support going forward because you are receiving those dividends.
Yes, ma'am. As long as they stay in my name.
Okay. Are you asking for retro child support, for back child support?
So I was looking for the retroactive child support just because I have had no support the past 4 or 5 years whatsoever. I didn't really know how that would work since we're not doing the child support. I didn't know if I could still get retroactive child support or not. But I am curious about
have
that.
you received any money for your child?
Other than the dividends that my child is owed from Paul himself, no. I mean, he bought a pair of shoes last month, but that was about it.
Oh, wait, what do you mean by the dividends that your child is owed?
So my son's dividends are in his name. I just have like primary control over it. And then Paul gets dividends of his own. So like, I guess what I'm getting at is the lady I talked to earlier said that y'all might take the retroactive child support amount of $19,000 and subtract the $18,000 I got for Garrett like 2 months ago out of it, so he would only owe like 1,000 something. But I was confused by that because then it would be like Garrett paying Garrett. That would be coming out of Garrett's money. So why would it come out of my child's money and not his money is where I'm confused.
Okay, so you're saying you received $18,000 for your child 2 or 3 months ago?
Yes, and all that went into a trust fund that I already had set up. So I don't even have none. All that's put up.
Okay, do you have access to that money?
I do, but the way I have it set up is he's not getting it till he's 18 because I got in a car accident about 5 years ago and I got paid out so much that they set up my kids their own trust funds from that. And so I just added to it. Does that make sense?
Okay, so, but the 18,000, would it have come to you, like these dividends are coming to you that you're getting every 3 to 4 months?
It's direct deposit.
Okay, so the $18,000 was deposited in your account.
Yes.
And other than that money and the pair of shoes, have you received any other kind of financial assistance from Mr. Caldwell?
No, not that I can remember. It's been a while.
Do you have access to affordable health insurance through an employer or another source?
My son has Medicaid. And then I have the Texas Women's Health also.
Okay, okay. Now, if the county of Galveston County orders court costs, are you in agreement to give Mr. Caldwell a year to pay those back till 6/12/2026?
Yes, that's fine.
Judge, I pass this witness.
Okay, you may call your next witness.
Judge, I'll call Mr. Caldwell.
You may do so.
Mr. Caldwell, you identified yourself earlier. You're the father to the child that's before the court today, correct?
Yes, ma'am.
Okay. So you heard what I explained to the court earlier, that y'all are in agreement for zero child support going forward, because your child is receiving dividends from the ASRC, correct?
Yes, correct.
Can you explain to the court what that means?
Arctic Slope Regional Corporation is a corporation of the native people of the North Slope villages in Alaska, and it's a oil consulting company because we, as the people of the North Slope of Alaska, own the rights to the minerals and the land. So as reparations from the U.S. government, we have the ownership rights to the minerals and the land. And so oil is the main commodity of our land. So we're mainly based in oil consulting and oil connection companies. So the shares that each person is allotted is based on their blood quantum. And Garrett is 1/16th Native Alaskan, and that comes from my bloodline. And that's how he was eligible to get those shares. And he is not able to sell them or trade them or give them off to anybody. Those are his shares. And she has temporary custodialship of his ASRC portal. So that's his shareholding profile. But she doesn't have the rights to his shares because those were his birthrights. That's what our reparations from the U.S. government are for coming and infringing on our land. So we get the rights, and that's with the rights for the minerals. Then we work with other companies and corporations that pay us to come onto our land.
Okay, and so those dividends are your son's birthrights. Is it a lifetime benefit?
Yes, they do not diminish, and they can never be sold or given away or transferred to anyone unless he dies. And then even then, they can only be transferred to next of kin or distributed amongst other shareholders that already are in the shareholder pool or qualify for the blood quantum to enter the shareholder pool.
Okay, and your son being a minor, he's entitled to use those funds, or his custodian is, like Ms. Proctor, she's able to access them, or are they supposed to be
only
held
under
for
the
him?
premise? Sorry, only under the premise that you need to be an adult to operate a bank account. Otherwise, the ASRC portal itself will house all of the portfolio for his shareholding. So all of the profit and information that goes along with him being a shareholder, because technically he has a seat on the board, but that's a whole nother conundrum.
Question, so you began that with that you need to be an adult to operate a bank account, and that's not really true. Like there's all sorts of children accounts, and then I remember when I was growing up, I worked when I was like 16, 15 and had my own account. And I guess technically, I don't know, maybe my parents were somewhat in charge of it, but you certainly can have an account as a child with money going into it.
Oh, well, then he's, I'm sorry.
Like So does that change your answer, or is it still like it needs to go to an adult because he's underage?
No, I mean, if Garrett could walk into a bank right now and open an account, then he could get those dividends transferred over to his name, and then he could rightfully hold all power to his ASRC portfolio.
Okay.
He's not restricted by any age limit for ownership, but those are his shares. Those are his. It's just a matter of who has access to the portfolio to address where the money is being allotted. So the dividends would be like direct deposited to her account or to Garrett's account if Garrett had his own account.
So does Miss Proctor having access to his portal remove his own access to the portal?
No, he can go in person and prove his identity, which he would have to go all the way up to Barrow, Alaska. But he himself can also call in and prove his identity over the phone of, his social, and having set up the account and getting the information from the account, then he would be able to solely take over all control and ownership of his portal. Like I said, he's not restricted by any means whatsoever. It's his money. It's just a matter of, well, he's 7 years old. He doesn't have the real conception of debit cards and how to transfer money around through portfolios and bank accounts.
Okay, Mr. Caldwell, thank you for that. Now you heard Ms. Proctor earlier say that she's asking for sole managing conservatorship of your child. What kind of conservatorship are you asking the court for?
Joint.
And why do you feel joint managing conservatorship is in the best interest of your child?
From the get-go, one joint, so that way it's just not Garrett being affected by anything that a mother and a father, going through a breakup and not being together. Then it shouldn't be anything to him for them to, because I was with her for longer than the time frame that she had said whenever Garrett was born. I'd just leave it 6 months. So I'd known him for a while before we had actually split up, and I've always wanted joint custody, so that way it's not a fight over a child. It's
When was the last time you saw him in person?
Last time I saw him in person was on his birthday, and that
What
was
year?
because 2 years ago.
So of 2023?
Yes,
Do you communicate with him regularly?
not as regularly as I'd like to. No.
And why is that?
Me and Ariel's relationship is not good, and she takes it upon herself to personally make it more difficult for me to be there for my son. So either on a publicity standpoint or a personal standpoint, she's using my son as a pawn to ineffectively hurt me or get back at me or just disrupt what I was trying to keep with Garrett. She's trying to disrupt and always has, and I just never understood.
Garrett's 7. Does he have his own iPad, cell phone, communication device?
He has all of it.
Remember, I said, don't interrupt the person answering.
As far as I was told, no, he doesn't have his own stuff. He has access to technology, but as far as I know, no, he doesn't have any devices of his own. So that way I'd be able to stay in contact with him. But last time I was able to contact him, we were playing games across iPad, so he has access to a device somewhere.
Okay. And when was that last time that you talked to him?
April. And that was whenever me and Ariel were coming to an agreement where we had signed contracts for stating, how to move forward without going through the court system. But, she had signed everything, and I still have the documents. I emailed them to Miss Karen.
Okay.
In the document.
Okay. So since April, though, have you tried contacting him?
Effectively,
Have you called him since April?
no, haven't really had any communication with him because of Ariel. She purposely keeps me out of his life, so that way she can make it look like I'm not in his life.
Okay. So if the court orders visitation today, what kind of visitation schedule would you like with your son?
If I could have it set up for, the court's understanding and there not be any understanding or misunderstanding, I should say, alternating weekends for 6 months and then every weekend for 6 months and see how that goes.
Okay. Okay. Are you in agreement for any of those visits to be supervised?
Preferably not. I mean, I don't have a problem with them being supervised by like a cop or someone, but I don't want Ariel there supervising me. I don't mind if it's someone else, but I don't want Ariel infringing on me and my son's time.
So you're in agreement for supervised visits so long as they're not supervised by Ms. Proctor?
Yes, I'm going forward to not be supervised whatsoever.
Okay. Okay.
Can you flush that out more, because unless someone's paying for a police officer, they don't offer that service.
Okay.
Okay.
So it's not a verbal proposal because I can't.
Are you willing to pay for supervised visitation in like a public place like that? Or are you requesting for visitation to be supervised by a family member or another trusted individual?
Trusted individual.
Do you have a person in mind?
Not currently at the moment that I feel 100% comfortable with. So I was informed of this meeting last night at 8:43 p.m.
Okay, before we proceed much further, there's a lot of big issues in this case, really big issues, from everything from child support to back to the visitation to some very serious allegations. And it looks like nobody was even served before they got here today. Are you all ready to proceed with this? Is anyone considering calling a lawyer, maybe having representation?
I've been waiting to speak. After hearing
witness stand first, so it's not. I'm letting people speak. But okay. Yes, ma'am. Mm-hmm.
After hearing what he had to say, that was just crazy because he can see his son if he takes a drug test. I've told him that for years now. All I did was say, take a hair test. I will pay for it.
No, ma'am, this is not a negotiation right now. This was the AG's office presented this to me as if it was a hearing. So my question to y'all is, no one was served before today. Is anyone considering contacting?
I need an attorney.
Okay.
I need an attorney. Yeah, because it looks like this isn't going to get anywhere. I'm not agreeing to joint custody at all.
And ma'am, this is not a negotiation. No one's asking anyone to agree to anything at this point.
Oh, okay.
This is a trial. You're in court. I don't know how to make it clearer. This is a courtroom. And I think I said that in the beginning, and I'm the judge, and I'm listening to evidence to make a ruling right now. But I'm also aware that it appears nobody had this pleading before today. Is that true?
I've known about this for 3 months, and he's known about it for 3 months.
That I don't think anyone had copies of pleadings because nobody was served with paperwork. This is our third setting in this case, believe it or not. But I don't believe anyone showed at the previous settings. So let me check and make sure that's actually true.
I got the email saying that I had court today.
Okay, so you were present in November. I'm not sure who was present in November.
This is Mr. Caldwell's first setting.
Yeah, I'm not arguing with you, ma'am. I'm just stating a fact. It's his first appearance in this case. So whether or not he's known about it for 3 months, I don't think anyone got in deep with the issues in the case with either of you before today is my point.
Yeah.
So this is not a debate. This is not a negotiation. I'm merely asking, are you all ready to proceed today? Because there's a lot of issues here. I don't even know that. I think you all need to research more and brief the child support issue, never mind the other issues, which almost make that pale in comparison. So are people ready to proceed today? Are you all thinking about consulting lawyers?
I think I need to consult my attorney or an attorney because after everything I just heard, it's going to be a fight. So I think I do need to go a step further.
Okay, why don't we reset this case to later in the summer and give everyone a chance to consult lawyers and think about this and think about what's going on with knowledge of what this is now. June 11, maybe one of the August dates.
Yes, Judge.
Probably not during advanced because if people hire lawyers, the lawyers could be at advanced.
Oh, okay, Judge. Judge, just for clarification though, Miss Proctor, you lost connectivity several times today. Would it be easier if we scheduled this in person? I know you dropped off like about 3-4 times today.
I would much rather do this in person. Yes.
Judge, if we may, I know it's your court, if you don't mind us coming in person, or we can.
That's fine.
Okay. So the next in-person judge.
I will say, ma'am, for cases where people do have safety concerns, I do have a preference for Zoom. But if you prefer to be live, that's fine. Just be aware, there's bailiffs, but it's still,
I mean,
Wow.
I'm okay with Zoom.
okay.
I was just worried about the connection issues.
No, and I am concerned with connectivity issues too. I'm just letting you all know that, if you are live, that means you're live. So just be aware of that.
Okay. Anything's fine with me. Whatever you want. I just don't, I mean, we've been fine with connection this whole time. So until now, I guess.
Okay. So if we want to do in person, we want to do Zoom again, Judge, we can come back on August 11th or August 18th, or in person August 13th.
And again, I wasn't there or, watching people come in and out all day. So if you think it needs to be live, that's fine. I just want to make sure people, again, fully realize the implications of live versus Zoom.
We can try Zoom again, Judge. Let's August 18th.
Perfect.
So we will reset to August 18th.
While Ms. Proctor demanded sole custody and control, this time we have a mother, Miss Kelly, seeking protection and structure with a lot of accusation against the father. I mean, from harassment claims to missed visits. Let's see how the judge handles this.
We are here today, June 12th, 2025. It's 11:18 in the morning. I am Judge Phyllis Martinez Gonzalez. I am the presiding Title 40 judge for Court 44 here in El Paso County. Today, we are at a final hearing after a motion for new trial was granted. We have a SAPSER pleading filed by the Attorney General's office, and we also have two cross petitions suit affecting parent-child relationship. May I have announcements, please?
Tyler Kubinski on behalf of Ashley Kelly, and we're ready, Your Honor.
Karen Alexander, Assistant Attorney of the State of Texas. We're ready to proceed, Your Honor.
Okay. All those who will testify, please raise your right hand. You swear or affirm the testimony you provide this court will be the truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you. And lower your hand. Mr. Kubinski.
Your Honor, can we put on the record if the responding party is here?
Okay. And Ms. Alexander, who is the other party that is before the court?
The other party is, give me a second.
It's Cesar Rios.
Yes, Your Honor.
Okay.
Cesar Rios.
And let the record reflect that Mr. Rios is not present, and as such will be in default. Mr. Kubinski.
Your Honor, if I just one quick thing before Mr. Kubinski gets in. We want to let the court know that everything in the order that was entered from December 12th, 2024 will remain the same with the exceptions of the child support calculations and the possession and access.
Yes, that would be agreed. That was part of the order granting the new trial.
Yes, thank you.
Mr. Kubinski.
Okay. Ms. Kelly, can you please state your name?
Yes, Ashley Kelly.
And who is the child, the subject of this suit?
Ava Rios.
And who is Cesar Rios?
The father of my daughter.
Right. And how old is the child?
She's 2.
And you have been the primary parent, correct?
Yes.
Right. Is Mr. Rios employed?
Yes.
Okay. And what does he do?
He does real estate.
And do you know approximately how much his income is?
I do not. More or less, I would say from 1,000 to 4,000 for each house.
Okay. What does he do?
He does wholesaling. He picks up properties that have been abandoned or have debt, and he pretty much picks them up and sells them to real estate investors.
And how often does he do this?
I believe this is like his full-time job. He gets a house here and there, every 1 house every 3 months, more or less.
Okay. And so he also has other income, is that correct?
Correct.
What income does he have?
He has VA benefits.
Right. And you've provided to the court a child support calculation, is that correct?
Correct.
Right. And that's true and accurate, correct?
Correct.
And it's your own personal knowledge, correct?
Correct.
Your Honor, at the time we move to admit Exhibit P1 into evidence.
Ms. Alexander.
No objections, Your Honor.
P1 admitted.
And are there any protective orders in place?
Yes.
Who are they against?
Again, Cesar Rios.
And who are they protecting?
They're protecting me.
And why?
I was concerned for my safety. There's been a lot of issues I've had with him, and there was a lot of him following me around or things like that where I just felt like I needed to have something to protect me.
Okay. And you provided that protective order to the court today as Exhibit P6, correct?
Yes.
Your Honor, at this time we move to admit, I apologize, P8. At this time we move to admit P8, which is the protective order.
Ms. Alexander?
No objections from the state, Your Honor.
P8 admitted. Thank you.
Okay. And are you having any issues with Cesar Rios?
Yes.
Okay. What issues are you having with Cesar Rios?
Currently, he's pending charges I filed against him. He pretty much did, in other words, revenge porn. He posted sexual videos of when me and him were together. He posted them online. He sent them to my coworkers, to friends and family, and he was just threatening me and harassing me. So those are the charges he has pending right now.
Did you consent to him revealing those videos?
No, I did not.
And he was arrested for this, correct?
Yes.
And those charges are still pending, correct?
Yes.
And when did this incident occur?
December 2024.
Was this before or after your last hearing?
It was before this last hearing. We had one in March, but it was after our first child support court that we had in December.
And you provided a copy of those revenge porn texts, correct?
Correct.
Which we've labeled at P5, correct?
Correct.
Those messages have altered. That way, it doesn't show the actual images, correct?
Correct.
Are they true, correct copies of the conversation?
Correct. Yes.
Your Honor, we move to admit P5 into evidence.
Ms. Alexander?
I'm sorry, no objections from the state, Your Honor.
P5 admitted. Thank you.
And then you said he sent them to your employer as well, correct?
Correct.
And who did you work for?
With La Mente Behavioral Health.
Right. And did La Mente respond to that?
Yes, they sent him a cease and desist letter to stop bothering the employees, and he wasn't allowed to step into the facility.
Okay. And you provided that cease and desist letter to the court today, correct?
Correct.
And that's labeled at P6, correct?
Correct.
Your Honor, at the time we move to admit P6 into evidence.
No objections, Your Honor.
6 admitted. Thank you.
And have you had any issues with Mr. Rios?
Yes, I have.
Okay. Who was physically violent?
Cesar Rios.
Okay. When did this incident happen?
The last time it happened was on my birthday, July 17th of 2024.
Okay. Has he been physically violent before?
Yes.
And you provided a copy of his criminal record search, correct?
Correct.
Is it true?
Yes.
Has it been altered in any way?
No.
Your Honor, at this time we move to admit Exhibit P7, which is the criminal record search of Cesar Rios.
No objections from the state, Your Honor.
P7 admitted. Thank you.
And you also provided text messages from Mr. Rios, correct?
Correct.
And these text messages that he's working with housing, correct?
Correct.
Correct, I apologize. Labeled Exhibit P2, correct?
Correct.
And they're true and correct?
Correct.
And they haven't altered in any way, correct?
No.
We move to admit Exhibit P2 into evidence, Your Honor.
No objections from the state, Your Honor.
P2 admitted. Thank you.
And how has visitation been with Mr. Rios?
It's been inconsistent. He pretty much just kind of picks her whenever he wants, which is once or twice a week, every other week. He doesn't really want to have a set schedule. He just tells me that he wants to just pick her up whenever he tells me. So I just want to have something written and have a set schedule that I could follow.
Okay. And you provided a copy of the visitation that he's exercised, correct?
Correct.
And that's been labeled at P4, correct?
Correct.
And is it true and accurate?
Yes.
Has it been altered in any way?
No.
Your Honor, at this time, we move to admit Exhibit P4 into evidence.
The state has no objections, Your Honor.
P4 admitted. Thank you.
Now, Ms. Kelly, how did you keep track of his missed visitations?
Just with a calendar and messages. of when he does pick her up and he doesn't. To begin with, the court order we had back in December from the very first court, all the days he was supposed to get visitation, those are the days that I counted that he missed visitation. And after March, when we have no orders in place, I just counted the days that he actually has picked her up, which are very minimal.
Okay. And for the last month of May, he only had 5 visits. Is that correct?
Correct.
Right. And during those times, did Mr. Rios let you know that he was not going to pick up the child?
No, he did not.
Okay. And so did you make plans that you had to cancel or change?
Yes.
Okay. Is Mr. Cesar Rios dependable?
No, he is not.
Okay. And you provided, no, I apologize. You provided a summary of the relief you wanted, correct?
Yes.
And that's everything that you want, correct?
Correct.
Your Honor, we move to admit the relief requested. We will make it exhibit, or as an aid to exhibit P10, I guess.
Your Honor, the state has no objections with the exceptions of the requested relief as to uncovered medical expenses and reimbursement of medical expenses.
Okay, duly noted. P10 admitted.
Thank you, Your Honor. And in that requested relief, you're asking for him to have the standard possession order for child under 3, correct?
Correct.
And you're asking that he have no overnights, correct?
Correct.
And you're asking for child support, correct?
Correct.
Which you've provided in exhibit P1, correct?
Yes.
And that total, or his child support, is supposed to be $939.52, correct?
Correct.
On a monthly basis. And I pass the witness.
Ms. Alexander.
I'm sorry, what was that dollar amount for child support? I'm sorry.
It was $939.52.
Just a couple of clarification. Mom, as to the VA benefits that Dad receives, how do you know that he received those?
Pretty much when we were together, when I was filing for Champ VA for the health insurance for my daughter, he had to provide a letter of his benefits that he received. So that's where I know the amount that he receives.
Okay,
From-
so you've actually put eyes on some kind of document that states how much he receives, correct?
Yes, ma'am.
And I just want to clarify, does Dad have any other children other than the child before the court?
Yes, he does. He has 2 other children.
How many?
2.
2 other children. Are they biological children under the age of 8? Okay. And I got a little sidetracked. So the child support amounts, are you requesting that the court order these new amounts to start as of January 1st, 2025, the same date as what was in that order that was entered in December of 2024?
Yes, ma'am.
No further questions, Your Honor.
Thank you. Mr. Kaminsky, any other witnesses?
No, Your Honor.
Can I also ask?
Ms. Alexander, did you have any witnesses?
No, Your Honor, no witnesses from the state.
If I can have the closing remarks.
And Your Honor, we just ask for a wage garnishment because there has been no child support payments since the last order.
Thank you. And Ms. Alexander,
Oh, no further questions, Your Honor.
any closing remarks?
No closing remarks, except just to ask the court to set child support based on the guidelines and the testimony presented to the court, and for that child support amount to start January 1st, 2025.
Based on the testimony and evidence before this court, I will grant the new child support obligation in the amount of $939.52. That is to begin January 1st of 2025 and monthly thereafter. I will also grant the standard possession order with no overnight visits. And just so that I'm clear, Mr. Kaminsky, did you, in your request, you had the pickup and drop off at the residence of Miss Kelly. Did you still want that, or did you want it to be at a public location?
Yes, ma'am. My residence, please.
Okay. So
And Your
then, go ahead, I'm sorry.
I do apologize. We also would request for the parties to speak through app close because there's been complications.
Miss Alexander, it looks like you wanted to say something?
Yes, Your Honor. So, I mean, obviously I do not represent Dad in any of this, but the protective order says that Dad's not allowed to be within 200 yards of Mom's residence. And how's he
Right.
going to?
So I saw that. That's why I was wanting to know. I don't want to put orders in place that would be direct in violation of that protective order. So that's kind of why I was asking about the public place.
Your Honor, can I have a moment, just a quick sidebar with my client to discuss it?
Iris, while they're doing that, did you get all of the exhibits that were admitted?
I'm sorry, Judge, if we can go over them. I have P5, P7, and P10, which is the relief.
Okay, I have P1. This isn't the way in the order. P1, P8, P5, P6, P7, P2, P4, P10.
Alrighty, thank you, Judge. I appreciate that.
Thank you.
And Judge, we would ask that, the exchange point be at the closest police department to our client's house.
Okay. Do you have, I'd like to put it in a
Record.
Do we have an address for that?
Let me see if I can get it.
Zaragoza, if possible.
Police station on Zaragoza?
Yes.
Let's make sure that we put that address in the order, but I will grant that request absent any pickup and drop off from its school. I don't think she's even old enough, right?
No, ma'am, she's 2.
Right, she's not old enough for that. And is she in daycare or anything like that?
No, ma'am, my sister watches her while I work.
So then that will be the location, and then until further orders of the court. Anything else, Mr. Kabinski?
No, Your Honor.
Okay, and Ms. Alexander?
What? So who's going to be doing the picking up and dropping off of the child on mom's behalf? Again, I don't represent dad, but I don't want the court to unintentionally put him in a position of violating a court order.
Well, the pickup and drop
because I
off
believe
will be at the police station off Zaragoza, and it will be by an adult designated by mom.
Okay.
And the same thing for dad, either dad or an adult designated by dad. Communication will be through app close. So if there's any changes in pickup, drop off, or identifying who's going to do that, please do that through app close. It does monitor all of the communication between the parties. Mr. Kabinski, how long do you need to draft this order, or who's going to draft the order?
Judge, Ms. Alexander volunteered, and we don't have any problem with the state.
So then, Ms. Alexander, how much time will you need, unless you can get to me by tomorrow?
I should be able to, Judge.
Let me give you another week. Let's do next Friday.
That would be wonderful, Judge.
No, not a problem. Next Friday by noon.
Now, we have Mr. Brown, a father seeking to reduce both child support and medical support to 0. The judge's response? Let's find out.
The court will note for the record that both parties are present at this time, along with the ad litem. But my understanding is at this time, the parties have married, and obviously that changes the circumstances of any and all custody orders once parties marry or remarry. It kind of takes everything out of the prospects of having to make any type of rulings at this time. So based on the fact they are married. So at this time, I ask the state for an opening to verify that information, tell the court what the state's requesting we do here today, and then I'll take an opening from the ad litem, and let's get some testimony from the parties confirming that circumstance under oath. Thank you. Or those circumstances under oath. Thank you.
Thank you, Your Honor. So my understanding is that the parties have gotten married. I've neglected to get a date of marriage from when I spoke with Mr. Brown, but I'll ask him some questions to that effect. My understanding is that Miss Gray does not want child support, or it was set at 0. I think she wants to keep it at 0. I believe Mr. Brown's going to request that medical go down to 0, and that would be in line with agency policy, I think, as the court knows. So no objection there. And then I guess it'd just be up to the court if the conservatorships are going to be kept in place, if the standard possession order is going to be kept in place. What the court wants to do as far as non-disclosure, we would ask for some direction there, but would love to finalize this today, Your Honor.
All right, then. Well, let's get some testimony. Let's see what the circumstances are, and you might want to get some testimony on whether or not the father is on that Medicaid grant, okay? Because that still might be a factor. All right.
It's just that, Your Honor, if they're a married couple, then it's our agency's policy not to request the cash medical reimbursement.
All right.
But yes, Your Honor, I can ask about the grant.
All right, then. Well, if that's y'all's policy, we'll go along with the policy then. Thank you.
Yes, Your Honor.
All right, this time, Mr. Brown and Miss Gray, y'all need to mute yourselves, and ma'am, you need to remain stationary while we get your testimony. All right, thank you. You're both muted, and so I need to get you sworn in. There you go, Mr. Brown, you're ready. Okay, there you are. Please raise your right hands, please. Do you both solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
I do.
Yes. All right, you're both officially under oath. You can both turn off your videos, and I'll let the state call you as witnesses and the ad litem cross-examine. Thank you.
Thank you, Your Honor. I'll call Mr. Brown. Will you state your full name, sir?
Sean Antonio Brown Jr.
Hey, and have you gotten married recently, Mr. Brown?
Yes.
To whom did you get married?
Precious.
And when did y'all get married?
April 21st.
Okay. Are you both living together?
Yes.
For how long have you been living together?
Dallas or Temple?
Well, so let me ask it this way. We did a temporary order in November. Have y'all been married? Have y'all been living together since November when we last came to court? Well, I guess we've come to court a couple times. Have y'all been married since November of last year? Or not married? Have y'all been living together since November of last year?
Yes, November last year. We were living together.
Okay. And then I take it your request is going to be for the court to take the child there. Well, we already have child support at 0, to keep the child support at 0 and take the medical down to 0. Is that correct?
Yes.
Okay. I'll pass a witness, Your Honor.
All right, your witness, Ms. Gustafson.
Mr. Brown, at the time that your daughter was born, were you present at her birth?
Yes.
And you signed her birth certificate?
Yes.
And y'all have now re-signed a new lease together, correct?
Yes.
And it's my understanding that your daughter is on CHIP.
Yes.
And is that through your wife's name?
I think so. I think she set it up
Okay. I'll pass the witness, Your Honor.
Where did y'all get married?
at the courthouse in Temple.
Okay, Bell County. All right, thank you. All right, thank you very much, sir. You can call your next witness, or anything on redirect to this witness, Mr. Diamond.
No redirect, Your Honor.
All right, call your next witness, please.
Thank you, Your Honor. I'll call Miss Gray. Ma'am, will you state your full name?
My married name or my name you guys got on record?
What's your name now, ma'am?
Precious Brown.
Okay, and it was previously Gray?
Yes.
Okay. You said your married name. When did you get married? So I take it you're married to Mr. Brown?
Yes.
When were y'all married?
I believe on the 21st of last month.
Okay. Have you been living together since the last time we came to court?
The last time. I mean,
I'm sorry, bad question. Have you been living together since the temporary order, which was November of 2024?
yeah. I mean, it's been off and on because I did put him out a couple of times, but we have been living together.
Okay. Has he been put out since y'all got married?
You know.
Okay. And then my understanding is you're wanting to you're wanting to keep the child support at 0 and take the medical down to 0 as well. Okay. And I take it you don't have safety concerns with Mr. Brown going forward?
Ma'am, I need a yes or no, please, because
No.
yeah, thank you.
Okay. I will pass a witness, Your Honor.
All right, Ms. Adlam, your witness.
Miss Gray, when we were in court, when y'all came to court on March the 4th, at that time period was a period when you had put Mr. Brown out. Is that correct?
Yes.
Okay. And that was when the court appointed me as an ad litem because you were having some concerns about Mr. Brown. Is that right?
Yeah.
And at that point, in November, there had been a temporary order set up where y'all were appointed to be joint managing conservators with you having the primary right to determine the residence of the child. Do you recall that?
You said November? When went to court?
In November, there was a temporary order set up where you and Mr. Brown were appointed the joint managing conservators of your daughter. Do you remember that?
Honestly, not really, ma'am.
So are you asking the court to appoint you as joint managing conservators now as permanently?
Yes, ma'am.
And are you asking to be the joint managing conservator that has the right to designate where she lives?
Yes, ma'am.
And at this point in time, you're telling the court that you don't have any concerns or safety concerns about Mr. Brown?
No, ma'am.
Okay. I'll pass the witness, Your Honor.
All right, anything on redirect on this, Mr. Diamond?
No, Your Honor.
All right, folks. What I'm looking at doing is I'm looking at going ahead and again, because of the concerns, I'm gonna go ahead and look at keeping the part you both as joint managing conservators, giving mom the right to decide domicile. I'm gonna find that y'all are married, however, at this time. And I'm gonna take child support and cash medical down to 0 to further order the court. And so as long as you guys are married, that's the way it's gonna be set up. But if y'all separate, then it's gonna be left to y'all to come back to court and get this done. But if y'all do separate, ma'am, you have the right to decide custody of the child after that separation. But for this time out, that's what I'm looking at doing. Is there anything specifically else that I need to rule on, Mr. Diamond, for the state to prepare this order?
So, Your Honor, the request would be to so the child support has been at 0, but if we
Right.
could take the medical support down to 0 beginning May 1, 2025, the state would request that's the date that we would request, Your Honor.
All right, so granted.
And then it sounds like non-disclosure is not going to be ordered going forward, Your Honor.
No, but leave that in the abatement. It's not, but I'm going to order it not going forward this time.
I'm sorry, I'm not understanding, Your
I
Honor.
was going to go ahead. It can be brought up later, but so I'm going to hold that in an abatement, sir.
Yes, Your Honor.
That way, it doesn't have to be something that happened after after this date. It could be anything that happened before this date could come into play on that. All right.
You got it, Your Honor.
All right. Anything else then, sir?
No, Your Honor.
All right. Ms. Gustafson, anything else anything else you're asking me to do here? Any other questions of either witness?
No, sir.
All right. I'm going to start with you, Mr. Brown. Anything else, sir?
Sir.
Anything else, Mrs. Brown?
No.
All right, and of course, I'll waive court costs due to parties being married this time, Mr. Diamond, and I'll actually prepare that order and circulate it to the parties, all right?
Yes, Your Honor.
All right, thank you both very much. Good luck in your marriage, guys, and y'all take care and be careful out there, all right?